welcome to Critical Insights, and welcome to the first episode in a new series we'll be doing about supply chain enforcement and compliance. My name is Andrew DeFilippis, and I'm a special counsel in Sullivan and Cromwell's litigation group and national security practice. And I'm joined today by partners Eric Kadel from the firm's general practice group, and Sharon Cohen Levin and Tom White, both from the firm's litigation group. Eric and Sharon are co-chairs of the firm's national security practice, and Tom is co-chair of the firm's international arbitration and global dispute resolution practice. Today, and in this podcast series more broadly, we're going to be talking about the ways in which companies' global supply chains are increasingly a source of legal risk and also legal opportunities. We're going to talk about how in-house counsel should be thinking about addressing issues relating to their supply chains. Let me just set the stage a little bit before we start. The primary observation that led us to launch this podcast series is that more than ever, companies are seeing legal and compliance risks converge on their global supply chains. Just think about all the recent world events that have affected companies' supply chains in pretty major ways. To give just some examples of that, we've had COVID and the disruptions it caused to the availability of basic goods. We've had recent Iran-backed attacks on shipping vessels in the Red Sea. There has been threatened blocking of shipping routes due to the recent conflict in Iran. There have been disputes over China's critical rare earth minerals. And of course, there have been the Trump administration's tariffs and the resulting trade disputes, negotiations, and deals. So all of these events have occurred against the backdrop of an expanding patchwork of laws that also affect companies' supply chains. And some of those laws include customs laws, most notably tariffs, economic sanctions, export control laws, anti-boycott laws, anti-forced labor laws, and things like the European Union's pending corporate sustainability due diligence directive. In today's discussion, we're going to focus specifically on tariffs, which have been much in the news lately. And in particular, we're going to tackle first the regulatory and criminal enforcement risks that the recent tariffs have created, and second, the potential for civil litigation under what's known as the False Claims Act. So Sharon, I was hoping we would start with you in talking about the Department of Justice. Customs fraud and tariff evasion are now listed as the DOJ's second highest white-collar criminal enforcement priority. What does that signal about how the government is approaching these issues?
Thanks, Andrew. It's a fundamental shift. For years, customs-related violations were typically addressed as regulatory infractions, or occasionally, in egregious cases, as criminal prosecutions involving false statements, conspiracy to defraud the government, or smuggling. However, those violations didn't even make the DOJ list of priorities. But the posture today is markedly different. DOJ has identified customs and tariffs fraud as a top corporate criminal enforcement priority, signaling a shift for companies with global supply chains. In particular, as you mentioned, the May 12 Gagliardi memo names customs fraud and tariff evasion as the department's number 2 corporate enforcement priority. That's a big deal. What's driving this renewed focus is the administration's broader national security and economic policy context. Many of the recent tariff measures were enacted under the International Emergency Economic Powers Act, IEEPA, a statute that was traditionally used for sanctions and export controls. IEEPA also carries criminal provisions, and so DOJ could now start using those tools, in addition to the other tools I've mentioned, to charge tariff evasion and customs fraud related conduct as part of a broader enforcement strategy. That said, given the recent and currently pending legal challenges to the president's IEEPA-based tariffs, the administration might want to be cautious in bringing criminal cases based on IEEPA. Regardless, it's clear that we've seen a fundamental shift in approach and that tariff and customs-related crimes are going to be prioritized. On a broader level, this reflects how the current administration views tariffs not only as a source of government revenue, but also as an instrument of foreign relations and national security policy. The administration seems to be using tariffs in a manner similar to how prior administrations have used U.S. economic sanctions. And it remains to be seen how the courts ultimately will view the legality of that shift in approach.
Eric, what are some of the specific schemes or practices that companies should look out for in the tariff space?
Thanks, Andrew. What I'm going to tell you here is a little bit from our own experience, a little bit from public reporting, but I'm going to talk about three particular types of practices that we're seeing. First is undervaluation of goods, where companies or their suppliers will underdeclare the value of imported items on invoices in order to reduce the amount of duties owed. We've seen, for example, where a supplier will prepare two different invoices for the goods being imported, an accurate invoice that goes to the importing company, and that is the invoice on which payment is collected, and then a false invoice that goes to a customs broker and ultimately to customs. This is sometimes referred to as a double invoicing scheme, and of course violates both CBP regulations and U.S. criminal laws. Second, what we've seen is the transshipment typology. Under that scheme, goods manufactured in high tariff jurisdictions, particularly China, are routed through third countries like Malaysia or Mexico or Vietnam, and then falsely declared as having been manufactured there. In order to execute this kind of scheme, what is done is they obtain a false certificate of origin for the goods. The point, again, of this scheme is to avoid paying the higher tariff associated with a particular country. It is similar to what we've seen in the economic sanctions context to a degree, where parties based in Iran or elsewhere try to mask the true origin or destination of goods in order to evade or circumvent the application of sanctions. In this case, they do it in order to evade the application of a higher country tariff rate. The final scheme that I'll talk about is misclassification, where goods are intentionally mislabeled under tariff codes that carry lower duty rates. As our listeners may be aware, there's a document known as the Harmonized Tariff Schedule of the United States, which classifies nearly every product under a particular category and code. The tariff rate for a particular item is then determined through the Harmonized Tariff Schedule Classification Code. And what we've seen is that sometimes parties will purposefully misclassify goods to put them in a category that carries the lower tariff rate. In addition, I think what we're seeing in particular after President Trump's recent utilization of national security tariffs and just generally much higher tariffs is an increasing sophistication of the schemes. For example, there's a New York Times article recently that detailed a number of Chinese suppliers that are marketing services promising tariff-free shipments by having the Chinese exporter act as importer of record. These exporters will then use shell entities, often registered to third parties or dissolved after one shipment, in order to obscure the true origin or value of the goods. They will understate value, falsify country of origin data, and then dissolve before enforcement authorities can catch up. Schemes are sometimes even advertised through email solicitations, TikTok ads, even social media campaigns where Chinese freight forwarders and trading companies offer U.S. importers turnkey tariff evasion schemes.
Eric, am I hearing you correctly that it's not just overseas parties that are at legal risk? U.S. companies are also being scrutinized?
Absolutely. We certainly expect that the Department of Justice will look closely at U.S. importers who either ignore warning signs or actively benefit from these schemes. We especially expect this in light of the fact that tariffs are being prioritized so significantly in the Trump 47 administration. If a company fails to conduct due diligence on suppliers or turns a blind eye to obviously suspicious documentation or pressures vendors to find a way around tariffs, could find itself squarely in the enforcement crosshairs. Certainly, if they're not just hiding their head in the sand or turning a blind eye to practices, but actually actively engaging and encouraging such practices, they'll be even more at risk. But regardless of who commits the evasion scheme, the CBP regulations impose a duty of reasonable care on importers of record to ensure that the customs forms that are filed on their behalf are accurate, so companies can't simply blame an overseas supplier if it turns out that something wasn't done correctly. As in other areas of criminal enforcement, there's likely to be particular scrutiny around willful blindness, as I was noting. For example, if a U.S. company has continued to pay pre-tariff duty payments on imports from China, despite knowing that tariff rates have increased by 30 or 50 or even 145%, prosecutors and regulators could see that as an indicator that customs fraud may be occurring and that the importer either knew or should have known that was so.
Thanks, Eric. And Sharon, I want to turn back to you to ask about the financial sector. What role is the financial sector playing in this evolving landscape?
Thanks, Andrew. Financial institutions are increasingly seen as gatekeepers here. Much like in the anti-money laundering or sanctions context, we can expect that banks, trade finance providers, and payment processors will be asked to monitor for customs fraud and tariff evasion typologies. This could include, for example, money transfers relating to underlying goods originating in certain high-risk jurisdictions like China, the use of known transshipment hubs, and pricing anomalies. Although financial institutions don't handle the goods in a trade transaction, they often have enough visibility to spot red flags. In addition, a number of the criminal offenses that the government can charge in connection with tariff evasion are also predicates for money laundering. For this reason, financial institutions' efforts in this area are not only analogous to their BSA AML compliance obligation, but rather they are a part of those obligations. In line with that, I expect we will see FinCEN release advisories relating to tariff evasion and customs fraud typologies, just like they've done for trade-based money laundering, narcotics trafficking, and other conduct. Companies will then have to adapt their financial crime programs to include these additional trade-related risks. It's not just about who the counterparty is. It's about what goods are moving, where they're moving from, and whether the declared value and origin are economically credible. Trade finance due diligence obligations are expanding, and financial institutions need to understand physical supply chains, not just wire transfers.
Sharon, given all of that, what does this mean for compliance expectations and compliance personnel who are dealing with these issues on the ground?
Well, recent guidance from CBP and DOJ suggests that tariff compliance is no longer a back office obligation. It has become a core component of corporate risk management. Tariff compliance has moved to the center of the regulatory white-collar enforcement agenda. Companies need to treat it like they would FCPA or AML compliance, complete with internal controls, documented processes, executive training, and real-time supply chain monitoring.
Eric, so is all of this part of a much larger enforcement and policy ecosystem? What's the context?
Yeah, exactly, Andrew. We're entering a high tariff and high enforcement environment. DOJ has signaled that it will pursue these cases with the same intensity as securities or sanctions violations, maybe even more. And CBP has reported seizing hundreds of millions in underpaid duties through targeted reviews. That includes $630 million in a single week tied to 2,000 shipments flagged for duty evasion. Bottom line really is this: companies must treat customs fraud as enterprise risk. consequences are not just reputational, they're legal, financial, and operational. And for those still operating under pre-tariff assumptions, the message is simple. The rules have changed.
Tom, I now want to turn to you to talk for a little bit about the False Claims Act. You and I have written an article in Bloomberg Law about how the False Claims Act has become a frontline tool in the government's tariff enforcement strategy. But for those listening who may not be familiar with this law or this area of the law, what is it that makes the False Claims Act such a powerful statute in the trade context?
Thanks, Andrew. The False Claims Act is fundamentally about ensuring the government receives what it's owed. One thing that makes the statute so potent, especially in the trade space, is the low standard for liability. The FCA doesn't require proof of a specific intent to defraud. Companies can be held liable if they submit false information knowingly, which includes acting in reckless disregard or deliberate ignorance of the truth. So that's a lower threshold than what's required for criminal prosecution under criminal smuggling or IEEPA's criminal provisions. So now apply that to customs. Every year, U.S. importers file more than 30 million CBP entry summaries, or Form 7501s, which are used to declare goods entering the United States. Each of these forms declares the classification, value, and origin of imported goods. So even if a small fraction of those forms contain misstatements, whether through undervaluation, misclassification, or misreporting the country of origin, they can trigger FCA exposure. And because penalties accrue on a per-claim basis and can include treble damages, the substantial financial stakes can be pretty staggering.
Other than the burden of proof, what else makes the FCA such a powerful tool?
Right, so there's the burden of proof, but another aspect of the FCA that's somewhat unusual is who can file the lawsuit. First, the government, through the DOJ, can initiate and file its own civil claims, but private parties can also initiate civil claims through what's known as a qui tam action. In those circumstances, a company employee, for example, who is aware that the company is committing tariff evasion, could file a complaint under seal. The government then has the opportunity to adopt the case if it wants to, conduct an investigation, and ultimately bring civil charges. And if they do bring charges, then the private party, known as the relator, is entitled to a portion of the recovery. So there is an incentive to report viable cases, and the damages can be quite high. The government can seek treble damages in addition to a per violation penalty. Therefore, in addition to paying restitution, companies can be required to pay large fines that are multiples of the total amount of underpaid tariffs, not to mention, of course, the reputational harm of being branded by the Department of Justice as a tariff evader. Finally, whistleblowers aren't the only private parties who can bring claims. Virtually anyone with knowledge of the scheme can do so. And as a result, companies who abide by the law and want to level the playing field can actually bring cases against their competitors for tariff evasion and then be the one to collect a portion of the damages. So the use of the FCA isn't just a potential litigation risk for companies, but it could also be a litigation opportunity.
And in terms of the DOJ's appetite to adopt or pursue these qui tam cases, are we seeing them take a much more aggressive enforcement posture here, much like in the criminal context?
Yes, we are. The second Trump administration has made tariffs a central tool of economic policy. Attorney General Bondi has pledged to use the FCA as an enforcement mechanism in that effort. And similar to the criminal division, leadership at the civil division has made clear that tariff compliance is now a core enforcement priority. So this is part of a whole of government effort, DOJ is coordinating closely with CBP, Homeland Security Investigations, and the Commerce Department to investigate systemic noncompliance, companies that treat customs paperwork as a check-the-box exercise while pursuing strategies to circumvent tariffs. And the FCA provides the DOJ with a uniquely flexible civil tool to pursue these cases at scale.
How, though, are the investigations playing out in practice in particular cases, Tom?
Well, we've already seen a case in which a company filed a qui tam claim against a competitor company. Specifically, a company called Evolutions Flooring paid $8.1 million after CPB and DOJ found that it had misdeclared Chinese goods as Malaysian. That case involved years of document tracing, supplier site visits, and forensic audits. So unlike in most FCA cases, the party who initiated the lawsuit in the Evolution case was not a whistleblower, but rather a competitor, the California-based flooring company Urban Global, which will now receive $1.2 million of the $8.1 million settlement. Other examples of recent FCA cases against companies for customs fraud include a $22.8 million settlement with International Vitamins for misclassifying products as duty-free, and a $10 million settlement with Precision Cable for invoice manipulation. In each case, DOJ emphasized not only the financial recovery, but also the deterrent signal to other market participants.
And from a corporate compliance perspective, what are the key takeaways for companies who don't want to be sued under this law?
Well, first, internal controls around customs declaration should no longer be viewed as just an operational detail. They're now central to legal risk management. Import compliance should be reviewed with the same rigor companies apply to FCPA or anti-money laundering protocols. Second, it's a multi-headed hydra because there are criminal risks, regulatory risks, and risks of both private civil litigation and DOJ-initiated civil litigation. A civil FCA subpoena can easily lead to a criminal referral and possible prosecution if there's evidence of intent. By the same token, an inquiry that starts out as a criminal investigation but doesn't reveal clear-cut evidence of intentional misconduct could morph into a civil claim where the government then only asks to prove recklessness. And finally, and this is crucial, DOJ has been clear, proactive compliance matters. Companies that self-audit, remediate, and disclose issues will likely be treated differently than those that ignore internal red flags. The goal is not just to mitigate risk, but to demonstrate to enforcement authorities that your company takes tariff compliance seriously.
That's a really good overview, Tom, and it definitely seems like the False Claims Act, which may not have been designed as a trade statute, in this environment has become a really central tool for tariff enforcement. And because of that, a growing area of regulatory and litigation exposure for a lot of companies, including global importers. And just to close out for this episode, Sharon, what do you make of Tom's point that companies should be proactive in this area?
I think it's exactly right. The DOJ recently revised its corporate enforcement policy to further incentivize voluntary self-disclosures. It used to be that if a company timely self-disclosed a violation, cooperated with the government's investigation, remediated, and didn't have any aggravating factors, the presumption would be that they'd get a declination of criminal charges, meaning that in most cases, no fine, no charges, nothing. Under a revised policy announced just a few weeks ago, a company that meets those criteria won't just get a presumption of a declination, rather they'll get a guaranteed declination. The message the DOJ is sending to companies here is clear. Don't let us find you. Come to us and disclose. If you knock on our door, rather than the other way around, we're going to treat you better. And that's because it is in DOJ's interest for companies to keep an eye out for criminal activity like tariff evasion and to report it right away.
So that's all the time we have for today. Thank you, Eric, Sharon, and Tom, for joining me in this first Critical Insights podcast about supply chain compliance. For more information about our practice, please visit us at www.sulcrom.com.